facility, I guess that's in parentheses, the foundation will not need to span the full 5 feet we recommended originally, but we don't have the exact number yet. So that basically gives you an idea of where this additional engineering is heading. And it basically is just costing me money. And what I anticipate is I'll have paid more money, wasted more time to put in the foundation probably after the ground freezes, that will probably end up being less conservatively designed than the one I originally proposed to build in the first place. And so that's where my heartburn with this whole process is, because I did the third-party plan review for a reason, because I knew that this would happen. In 1997, also a little more background, I grew up in Turnagain, right on the bluff. My dad built the first house in 1990-91, and then in 1997, he built a second house, and we're going through the permitting process. He encountered the same difficulty where the municipality could never really find enough engineering for them to feel comfortable approving something, and that ended up at the building board, in which case the building board said, we're going to delete all seismic requirements on this house. You're going to design it for wind forces and everything else will be normal, and we'll just ignore seismic because we can't figure out how to approve it. So, you know, we have plenty of history building in the area and, you know a lot about it. So, 2 years ago, I hired Northern Geotech to do an investigation of 4 lots. Lots 7, 8, and 9, Simonson Estates, and then another lot 8 on the other side of the street in the same subdivision. And the one on the other side of the street had slightly different recommendations. The lots 7, 8, and 9 are directly they're adjoining lots. They're on the south side of the street, and they encountered all the same soils types, so therefore they had all the same geotechnical recommendations. So last year, Pete Eberhardt, he kind of partnered with me on the report. We hired it together. He built his house with no alternate means and methods. And then this year, we applied for our permit. We had it engineered by engineers. We had it reviewed by other engineers. We had the same geotechnical report. And now we've been asked to provide an alternate means and methods. A little more background, I've built a lot of houses in seismic zone 4 and 5, and we've never needed a alternate means and methods for this case. This is what I feel is something that was, maybe it's probably always been in the code. I wouldn't say that they made it up, but I think that the third-party plan review process gave the municipality the inspiration to dig a little deeper into the regulations to find something new. That's my feeling, and that's really why I'm here today. Since then, I've also had a Bootleggers Cove 4-plex building. It's built in a subdivision called the L Street Side replat. I think the name alone indicates that it's in an area of known ground failure. It's replatted because it slid in 64 earthquake. And the municipality approved the structural on that without an alternate means of methods. And that was really, I think that was in August after this had already come about. So to me, the municipality's policies are inconsistent and it's glaringly obvious. And that's really most of my case. I mean, I have other stuff I could go on about, but I'll maybe save that for the rebuttal. Unless you have anything to add.
Well, you know, I think that and Andre knows much more about the technicalities of all this than I do, but in this one letter that we got from Building Safety, the premise was the ground is unstable. And, you know, the ground has been there for 49 years now. It's pretty much stable. They studied it in '95 with Shannon and Wilson. They had Ray look at it. You know, when you read the conclusions, it says the ground is more stable today than it was then, and that the area where we're building it, where it's been flattened out, is more stable than what's right above it. So, you know, they give a 475-year reoccurrence rate in it. I mean, I don't understand what we're talking about. These are single-family houses. You know, I built 3 of them within 200 yards of this on the bluff, same situation. Houses went down, we rebuilt on them, and, you know, we've been through this over the last 20 years, and now here we are jerking around with this. It's just inconceivable that we're here doing this. And part of the last Bragg report, it said the municipality should just come up with a standard plan and for what we need to do for these foundations, and just so it'll be easy to do it. And, you know, Keith Mobley has, you know, he wrote this, he was one of the co-signers of this 95 Shannon and Wilson report. He's been studying this thing forever. And, you know, his knowledge goes back to the very beginning, and we've just been following his lead. So I just don't understand how we could be sitting here, you know, without a building permit at this point.
Okay. Staff, you want to present your case?
Do you have any questions of the,
Well, I thought
do you want to go ahead?
I thought we'd present both and then
Okay.
start with questions, because you may answer some of our questions in your
Okay.
presentation.
All right, well, the case focuses on, has the municipality changed its procedures in requiring alternate means and methods for this property versus the property next door? That's the bottom line. We've received some additional history and background that we can speak to if you like. I'll wait for you to ask the question on that. We maintain that we have not changed our procedures. There's been no change in policy or interpretation of the building code regarding dwellings constructed in this area. The house on the neighboring property did provide an alternate foundation by the time their design was approved that would perform as well as when built in a less hazardous area, albeit through the usual give and take of the conventional MOA design review process. What they did not do, what we did not have, was the formality of a submission of an alternate means and methods form. With that, we can answer questions as to additional history, as you wish.
Okay, then I guess I need to offer you a rebuttal before we start asking questions.
Well, yeah, sure thing. So through your review process of the Eberhart house, you say that they did construct an alternate foundation. I'm assuming your reviewer was reviewing that foundation per the recommendations of the geotechnical report, and that's the alternate design. Well, that's what the alternate design was based off of. And my plan already has that. My plan was designed per the recommendations of the geotechnical report. It was designed to have the 10-foot spans that they now say is conservative and will likely not be in their future recommendations for this house. So I guess I would just say the foundations were designed alternately if what we're comparing them to is all the other foundations in town. It's not an alternate foundation. It's just the foundation that was designed per the geotechnical report.
Okay. All right, let's go into questions. I'll start. So, was the design submitted as an alternate means and methods? I thought I heard you say that earlier, and then later I heard that the municipality later required it.
No, the plan was, I came down to submit the plan, normal, except for the fact that it was done under a third-party plan review. And, you know, because I went through the code cycle, and I tried to get an engineer stamp on a residential structure removed from the requirements of seismic zone 4 and 5, because it's very difficult to have engineers working on houses. It's very difficult to find them that will even work on them. And then it's very difficult to have the muni review them. So that's really why I did the third-party review, is I didn't want to be stuck in the middle of an engineer and the municipal reviewer. So I come down to submit the review, and at the counter, or the tech, I believe, took it to Mark, and Mark said, this is going to require alternate means and methods be filled out for you to submit this permit. And this was after I had submitted the one in June, which is still kind of pending, up in the air, pending this additional geotechnical information that's forthcoming.
Okay.
So that's when the alternate means and methods was filled out. And I kind of took it as a, okay, new hoop, better jump through it. And then it was later that I decided that I thought that the municipality had changed the way it was, its procedures, and I wanted to appeal it. And here we are.
Okay. Next question. If the plans were submitted under a third-party review, and the building department was aware that the seismic hazard zone 5 issues had been looked at by both a geotechnical engineer and a structural engineer, then why was the building department asking additional questions?
Okay. First, let's talk about alternate means and methods as relates to the exempt review ordinance. The exempt review ordinance does substitute a reviewing professional for the standard plan reviewer at the municipality. And it requires an architect for life safety, fire type items, and a structural engineer for structural items to sign off. So they're certifying that the design is code compliant. They fill out paperwork and submit that, I certify that I've reviewed this for code compliance. However, the alternate means and methods is what you need at a time when you cannot be code compliant for whatever the condition is. So you submit an alternate means and methods to show that you're equivalent in safety, strength, durability to what the code requires. It's a way of showing, no, this doesn't meet the letter of the code, but it meets the intent of the code because we've done these extra things to make it just as strong and safe. We've had the municipal attorney's office has reviewed whether or not the independent reviewing professionals have that authority by right of this ordinance, and they have determined that they do not. The approval of an alternate means and method rests strictly with the building official and designees. So in the case when someone has something that does require an alternate means, what they would do for an exempt review, bring in the alternate means saying, this piece of this design requires alternate means and methods. We need approval from the building official. That piece is what the building official looks at. It says yes or no. Let's say they say yes. Then the designer takes that back, has the alternate means approval, folds that into their design, the reviewing professional reviews the entire package and notes that the alternate means and methods included for the approved piece. So that's the relationship of alternate means and methods to the exempt plan review. In this case, we did do the letter that Mr. Spinelli referred to that they received from us was a memo from our department, the code path, as to how we determined that this required alternate means and methods, projects in this area on this site that's previously had ground failure, why it would require alternate means and methods, and I will let staff speak to that.
Is there a copy available?
Go ahead.
I think there's a confusion on what alternate method entails. I think the Spinellis are basing it on the form rather than the issue. So whenever the code is not met exactly, if you aren't code compliant, then you have to turn in an alternate methods and means. This subdivision, this area, this very northwest area has been shown to not meet the code requirement of the factor of safety 1.1 against ground failure. Therefore, anything that's built in that area needs an alternate methods and means. And we have been not necessarily consistent on requiring the form be filled out, but we've been absolutely consistent on requiring the geotechnical report to address the issue and that the structures be designed. And then we have reviewed those as an alternate method. Let me give you a copy of the code path.
And this confirms, this is the memo of July 17th that you guys already do have.
And I will say that the house that is right next to it, absolutely, plan review is required if they follow the geotechnical report with an alternate foundation to make it essentially or equal to prevent collapse in the ground instability issue.
If I might just ask a question, what was handed out is making reference to a permit number in the subdivision that differs from the appeal.
Yes.
Could you describe the reasoning?
This is the reasoning is exactly identical. This is the first one that we sent in.
This is the Judah one?
It's placed.
Yeah.
Okay. Did you receive a similar one for?
No. No. I think that the municipality and myself have probably kind of meshed them both together. The reason I brought this case forward is because we actually submitted this one knowing what we knew on this one. We thought we were more prepared, better off, and I have a buyer for this house that's very eager to move. So that's why this is his sister.
And my daughter.
So I guess I'm not understanding why alternate means and methods would be required if you're not code compliant. I'm not understanding why we're not code compliant. I know that local amendments require that if you're in seismic hazard zones, whatever it is, 4 and 5, that you have certain things done, like a site-specific geotechnical report that addresses liquefaction and ground failure. And it sounds like they've done that, and they've designed the residents and the foundation to meet the requirements in the report. So how are we, I'm not understanding how we're not code compliant.
The code requires that you meet a factor of safety of 1.1 against ground failure. That means it's got to be stable. So if you're not stable, if you don't meet the code requirement of 1.1 factor of safety, then it becomes an issue of alternate methods and means. So now you have to create, as an alternative to meeting the stability issue, you have to create a structure that will remain intact and won't collapse due to ground failure.
And is that issue addressed in the Northern Geotechnical report that you have? The factor of safety against ground failure?
I believe it is. I thought that your major hangup was that the slope stability analysis that they did was not compliant with section 1803, and I asked Keith Mobley if he'd ever done one. He said no, and I asked him what it would take to do one, and he said probably 150 grand. And since I know he's done the geotechnical reports for probably half the buildings in seismic zone 4 and 5 around this town that have been built recently, I don't know how anyone else is any different than me, because I'm hiring the same engineer to provide the same engineering.
At this point, I think it would be helpful to hand out the folder.
Well, let me just say that none of these reports none of, all the stuff that Mobley has come up with have not been an analysis to show that the factors in 1.1 has been met. He's essentially said it's going to slide. Therefore, this is what I think you need to do to solve the problem of the design your structure. So the alternate methods and means is partly the geotechnical engineer giving his way of designing the foundation, and then the structural engineer meeting the requirements of that. Those are what we review as both parts of the alternate methods and means.
If I might, did I hear correctly what in essence you're saying, Ron, is Mr. Mobley is saying that it can't be done, but here's the best that should be done, and then the engineer does that?
Here's an alternate, so I'm saying it can't be met. In that area, we know it's slid. We've got several soils reports says it does not meet the factor of safety requirement of 1.1.
Okay.
So right there, it doesn't meet the code. That means in order for it to go forward, they have to present a design, a geotechnical report combined with a design that will show us that now that the ground's going to fail, that the building will remain intact.
And so every other development in this setting has complied, that's been permitted and built has complied with this process?
Yes. And typically, the way of doing that is building the mat foundation, where the whole building kind of holds the whole building together. That's the typical way of doing it.
And this has been both residential as well as commercial?
Yes. That's not the only way. That's the main way people have addressed that issue.
So what you have in front of you now is the report from Golder Associates that reviewed both the technical report and the foundation structural plan for this application. They did find some minor issues with the technical report. And, Bill, if you want to summarize it a little more, required with the findings of the...
I am not.
Oh, you're not? Pardon me? My mistake.
This is the first time I've seen the report.
Oh, I'm sorry, I have the wrong staff person in line.
Well, at the bottom of the first page, under 2 geotechnical report review, that highlighted sentence there at the end of the, they basically are agreeing with what Ron just said, that specifically seismic liquefaction and local seismic slope stability evaluations have not been presented. I mean, that's basically what Ron just told you.
So, if I may, on the building that's built right next door, they did go through a alternate means and methods design that met the MOA's approval. Is that correct? But they didn't fill out the actual alternate means and methods form, essentially, but a design was presented.
That's correct.
And it was approved. Is there a reason why just the same foundation design wasn't used on this, knowing that worked? I mean, again, I don't know if...
We designed it, the engineers, we hired engineers to tell us how to design it, and then we hired engineers to design it the way that geotechnical engineer designed it.
And what he said is true. Every house we built, I built 4 houses over there in the same exact area. We put type R, 2 feet of gravel, type R, 2 feet of gravel, and type R, and then top it off and pour the footings on them. I thought it spanned 10 feet. That's what the program was, and it's the same thing in every one of these houses. I just don't understand why we're talking about this. Everybody understands it. The reports, these big reports, the $250,000 reports, all say that the ground above it is more susceptible to failure than this settled out ground, because this ground has settled. And, nobody's requiring that up in, in Marston and the other areas here. And so, everybody's hypersensitive because this place slid at one time. And, I don't know, I just don't understand what they're talking about. She also mentioned the legal department looked at something and said we should do it this way. The legal department, when we were developing this subdivision, they told somebody else, Ingram, Simonson's grandson, that he owned the 3.5 acres in front of our parcel. So we had to go to court. We went to the Supreme Court to find out that we really did own all the property to the mean high tide. So, the municipality, although, I've got respect for the municipality and their legal department, they could be wrong at times, and they can also find in favor of the municipality. And, that's their job. When you have somebody that works for you, that's what you're supposed to say. So, saying that just because they believe that the alternate means and method is acceptable, I just have to question that. So, and I guess that's all I have to say right now.
So was the foundation for the house that this appeal is based on design the same as the foundation of the house next to it that has been approved? Or is it different?
I don't know what, I don't know what that, I didn't build that house, so, and I don't have the plans.
Like us to answer that?
Yeah.
Based on the comparison, I was involved with the plan review on the Everhart residence and had taken a look at the plans submitted by Spinelli, and they are significantly different. The plans that were approved were based on a raft foundation system that consisted of grade beams and a structural slab system. What has been provided is a conventional basement foundation. And so there is a significant difference with regards to the performance or the construction overall, plus a expected difference in performance during a design seismic event.
Okay, and I got one more question, and I think you have a question. I guess I wasn't aware of this, Ron. What you were saying is the code is specific that you must meet a factor of safety of at least 1.1 against ground failure?
Correct.
Okay.
And it's a copy of the building right there in the handout I gave you.
It would be starting on the bottom, on the memo, July 17th, starting on the bottom of the page.
Well, it's hard to decipher this if we don't know, if I don't know what the Northern Geotechnical Report, which addresses the property that we're considering here today, whether it addressed this requirement or not.
It should be sitting right in front of Ross.
Well, the Northern Geotechnical Report did not determine the safety factor. And that's actually commented on in the Golder Report.
Okay.
On it, so.
This is, we're receiving a lot of information the night of, and we'll work our way through this, but it seems like all of the stuff we're receiving and kind of talking about isn't the issue, because the appeal is made on the basis of this municipal policy. And an interpretation if this process deviates from this policy or is part and parcel. So I guess my question would be and we may not have the time with this as well, but I guess my question is, this document, this procedure for changing and enforcing codes and policies that was issued by the municipality, has been in place for some 13 years. It goes through an annual review according to the document. And what you've heard in terms of part of the presentation tonight is that the municipality may not have done it the same way each and every time. Taking that at face value, would that then not, if that was evidenced, would that not state that they are in fact following a procedure and policy, which then makes the appeal kind of moot? We have to move on to an appeal that deals with substantive issues of engineering and design? I mean, I don't want to get picky, but that's what's been presented to us in my mind.
A couple things, because surprisingly enough, lawyers are always concerned about ethics. From an ethical standpoint, I can't give advice to the board here tonight. I'm here on behalf of staff. You can, if you wish, consult with another attorney that, you know, in our office. That person is not available now, so you need to continue. But when one attorney is basically advocating for one side in a board situation like this, then we don't get into giving advice. The other thing I'd tell you, I mean, it's unlikely that if I were in a sense the board's attorney, that I'd be giving advice off the top of my head on something like that anyway.
Well, we're here on the top of our hill.
Can I speak to that for a second? I think I understand your question, and I just want to see if this is what your question is. Your question is that they were sort of doing this without actually putting the policy out. And I think that's what you meant to, or were trying to say. I was instrumental in getting that policy adopted way back when. And, you know, I don't think you're interested in hearing why, but, you know, as home builders, we're not, you know, our job is to get it done in, you know, 60 days or 90 days and be on with life. So we have a tendency to go along with the municipalities' every whim all the way through. And at points, it got to a point that we just were getting jerked around tremendously. And we came up with this program, which a previous building official agreed with, that when they change their policy and they're going to start doing stuff differently, they would write out a memo, they'd hand it over to us, we'd see it for 30 days, we'd comment on it, and so we could react and do whatever, because we're, you know, every day we're signing a contract. And if the rules change, you know, every day, then we're, you know, if it changes in, on February 1st, when we sell 14 or 15 houses in a month, you know, it could cost, you know, $100,000 difference because they changed their policy. So they, as a courtesy and just so we could do business, they always put out a policy and say, this is the way it's going to be, so that we'd understand it. And, you know, we get along here. You know, we've taken over 2,000 building permits at the municipality. We know how to apply for a building permit and get one. And all we are asking for is to be treated fairly. And if they're going to change the way that they're going to approve things, they need to give us a memo, tell us what we're going to do, and then we're going to go ahead and do it. And, you know, they said, one of the comments in Golder was they didn't do 3 test holes. Well, I paid for two reports, really, and the third report on Pete's Place, lot 2. I've got you know, Keith Mobley did a test report for me in 2002 for lot 1 Pete's Place, and then I've got lot 2 more holes on lot 2 Pete's Place. So we've got like 5 holes within 120 feet of each other. So, I mean, you know, maybe he got complacent. You know, I know that there was a beehive involved why he didn't do the 3rd hole on this lot, but he also found sand down to 30 feet or something. So it's just like, you know, it's just not rocket science.
I appreciate the response. If I could maybe throw this out and follow up to where I was heading with this, is my history on the board, we haven't had appeals in quite a while, but appeals always seem to be a piece of paper that's filled out and the money's paid and it's kind of, now it's in the queue and the groups assembled. And we get packet information, and the packet information contains limited information. When we get to the event tonight, we start through questions and answering, and it's understandable, we start getting more and more detail. So I guess what I'm saying is, I have to take your appeal at face value, and your appeal is not based on anything to do with engineering. It was based on, does the municipality have the right to do what they're doing based on this procedural document? And that's where I was going with the question. If you do it the same way, or if you do it in a different way with the same result, is that procedurally different, is where I was going. So, I wasn't building on them with engineering. I'm trying to get to the point of what your appeal is. And that right now, in my mind, this policy.
Right, when I thought I was speaking to that, when I was.
Well, you told me the history of how it developed, and I appreciate it.
Yeah, it's just that we don't, you need to have a set of rules and then you play by those rules, and that's what, we thought we had the rules set out, and we turned them in and did it in that way.
Well, really, our set of rules is the municipality's not going to review these plans. That's the set of rules we're playing by, and it was written into an ordinance last year. And that's the rule. That's the rule I'm appealing. I mean, that's really why I am here. So all this engineering is just semantic.
The question that we need answered, is what I do before I can act on it, is the ordinance speak to other documents such as geotechnical reports that may be part and parcel. I read through the ordinance and it talks about third-party review for permitting. Now, permitting could be saying that it involves all these other documents, but is the geotechnical report part of that ordinance and third-party review and responsibility?
I think we can speak to that. We have spoken to it a little bit earlier, but...
Yeah, I mean, there was that opening that the opinion was that, no, that those documents are separate from third-party review.
Right, those documents are governed by the part of the code about submittal requirements, which has recently, well, there's a couple things going on with that. If we talk about what was in existence the day of this appeal, or the day of, what code said, it's the day of the application. Okay, did that change since then? So the day of application, if you go to the requirements of what is intended to be included with the packet, it goes to submittal documents. It's fairly brief, I'll read it. Construction documents, statement of special inspections, structural observation programs, geotechnical reports, and other data shall be submitted in accordance with the policies prescribed by the building official. Construction documents shall be prepared by a registered design professional where required by the statutes of the municipality in which the project is to be constructed. Where special conditions exist, the building official is authorized to require additional construction documents to be prepared by a registered design professional. So that's what was in existence on the day the application was filed. Since then, Ordinance 2013-91 has been put into place. By the time of the appeal, and I'm not sure which one's governed, I would expect it would be the one in effect of the date the application was submitted. But since the time of appeal, under 4 projects submitted under this ordinance, additional language has been added to say, a complete building permit application reviewed pursuant to this section shall include the following materials: 2 complete sets of building plans, 2 plot plans, a completed stormwater discharge permit application, a letter or review signed by appropriate independent reviewing professional demonstrating experience in structural engineering, certifying structural plans, calculation, fire code compliance, building safety, accepting responsibility for plan review as required by this section, and a signed release of liability, and 6, any geotechnical reports required by Titles 21 and 23 of the Anchorage Municipal Code. Goes on to say, supporting calculations, computations are not required to be submitted with the building permit application, but shall be kept on file by each independent reviewing professional until issuance of a final certificate of occupancy. Now, from there, we go back to the reviewing professional certifying as code compliant, which they can do for everything except something that would require an alternate means, which would mean they would still need to come to us, even with this new language, and submit their have the designer get a sign up for their alternate means, and the reviewing professional should verify that you've gotten approved alternate means for this alternate design.
But did Spinell Homes provide all that you just listed? For getting the alternate means and methods?
Yeah,
Yes.
they provided a complete submittal that was accepted into the system.
Okay.
They have since.
So the zoning went through, all the other reviews continued.
And I mean, I think that's what your appeal should be based on, is that you submitted, in my opinion, you submitted under the, the third-party review. You met all the requirements, but now the municipality, is basically asking additional review comments, which is...
That's what it says.
We would maintain they did not meet the requirements because they did require the alternate means.
Right.
The question is, what is alternate means and methods all about? And, to me, there's report after report of what goes on in that seismic area over there. And what he did is he took the ground that's there and he created a place where you're not going to have ground failure for 10 feet. And he's created a place that is now seismically, or at least for whatever reason, safe to build this house on. And when you have that pad there, it pretty much says that you can build a normal house on top of it. And so,
Well, let me go on and just say that Ron mentioned an alternate foundation. And my question is, where is this alternate foundation in the code somewhere? Did you write it down on a piece of paper, or did you maybe put it out on a sign out in Turnigan that said this is how the foundations need to be designed? Because what the code says is you design a foundation per the geotechnical requirement, and that's what my engineer did. And that's why I said, and it's not a standard foundation. It's different than a standard foundation. And most foundations in this town are different than a standard foundation. And I think you know that. Most foundations in this town are robust. And, so we did provide an alternate design, and I feel we met all the requirements of the code, and the municipality has required something new that they didn't require on any of the other alternate means and methods, or any of the other permits in this section. And I would challenge you, because you said we require a mat foundation on everything, I would challenge you to prove that. Show me the additions in Turnigan. Show me the houses that extend all the way out to south of Northern Lights, which is included in this area, which these reports say are just as susceptible to failure as this area, or more susceptible. Show me the proof that you're requiring mat foundations all the way out to Northern Lights.
We didn't say
You never
that.
said that.
We're asking questions, and we're getting beyond that, so thank you for that, but who else has additional questions?
May I make a point? One of the things pointed out in the Golden report was that the actual foundation didn't meet the geotech report because the interior columns weren't structurally tied into the foundation system as required by the geotech report. So whereas on the house we approved, everything was tied together.
And that's in the 3.2 paragraph.
Yeah, the first sentence of 3.2.
10 engineers in a room and you'll come up with 10 engineering solutions to every problem. That would be my answer to that question.
Well, I think maybe what's going on here
Ross,
is,
we need to go through the chair.
okay, through the chair.
Go ahead, Russ.
I think maybe Andre was assuming that this house was actually going to go on a reinforced earthen pad. And I don't think anything in the plans, I didn't review the plans, but by reading Golder's report, I can tell that they didn't see the house on a reinforced earthen pad. And in addition to that, they saw the house with just a typical foundation with interior column pads, you know. So the foundation system really wasn't tied together.
Any additional questions?
So I had asked Schneider to put the earthen pad on the structural plans. They said they never do that. That's not how they do it in commercial buildings. They said that if they put that on their plans and seal that, then they're practicing geotechnical engineering, and that's for the geotechnical engineer.
Does a geotechnical report require that type of
The
construction?
geotechnical report offers two options, the earthen pad or the reinforced, the thickened concrete foundation.
And you intend to
Yeah.
utilize one of those two methods in the
Yes.
construction?
But that's not shown in the plan?
Here's the plan that's not shown in the plans.
Yeah, I understand.
And the reason it wasn't shown in the plans actually is because I had a conversation with Sharon about it, and I said, well, they engineered it for the 10-foot spans, and then she said, well, then you shouldn't be required it. And I had already talked to Schneider, and they said they wouldn't put it on their plans, and so I just left it off my architectural plans. And, because I mean, in a lot of houses I've built, the municipality does this, they staple the geotechnical report to the plan, and we build off the engineer's foundation report. And so, to me, that's, you know,
Well, through the chair, I mean, the report appears to give the structural designer leeway or options, but then options are not specified on the structural design as to how he accomplished or met the geotech report. He could have easily have just shown a box under the house and said, reinforced earthen pad by others, designed by others, and then he would not be taking any responsibility for the design of that structure.
Through the chair.
Go ahead, Ron.
But again, we're getting off track. Ultimately, the whole issue before us here is we've changed our methods on any structure that does not give us a geotechnical report that shows that it does not meet a 1.1 factor safety for seismic ground failure. We require an alternate design. The design consists of a geotechnical report and the structural response to that report, and that is reviewed by the building official through the deputies. And we haven't changed that process at all.
Right, that is an alternate design, which is different than alternate means and methods.
So that's the same.
Well, you're making it the same, but
The paper, the filling form is not what constitutes the alternate methods and means. If it doesn't meet the code, it has to have an alternate method of constructing or designing the structure to meet the conditions that don't meet the code.
Right, yeah, I would agree. I mean, I look at it as the alternate design is that you have a site-specific geotechnical report and an engineer designs the structure and the foundation to meet those requirements. That's the alternate design. Correct. Any other questions? So I think what we need to do is we need, the three panel members need to vote, and I'd like to vote by ballot. And
Did you want to have deliberations in between, I mean, closing the,
yeah, but I wanted to make this clear first, that I want to vote by ballot, so you don't, in our deliberations, you don't need to you know, make your intent of how you're going to vote clear. Does that make sense?
Well, if I might, I guess, I don't know if this is a point of order or a discussion or a question. When we review these cases, and this is the first 3-panel I've sat on, but when we deliberate an appeal, we're looking to formulate support or non-support of that, and we're to then come up with a basis of finding the facts that led us to that. And usually discussing something is the way those are done. We can formally deal with those in the end, but I guess have the 3-panel actions today come up with findings of fact and the basis for that.
They have not.
Is the process changed, or are we looking for that? Or?
It's not, I don't think it's the same formal process as like a building board meeting.
Can we ask, could you talk to that? We believe we're following the subset of the board and it follows the same procedure, correct?
In this case, I just read from the regulation that we're under, which is 23.10.016, the order of business, and L, the findings of the board shall be specific findings of fact and conclusions of law. A affirmative vote of the majority of the fully constituted board is necessary to grant an appeal in whole or in part. So that part doesn't apply. Now, it talks about the board, but as a panel, you're part of the board. So my read of that would be that, because it doesn't say anything about the panel itself, but the panel would follow the same rules as the full board.
Okay, I mean, my statement that we don't conduct the panel procedures that way is based on the other two that I've been involved in.
If I could help. Back in the 2310, it's modified to allow the 3-member panels. It says 3-member panels, a building board, 3-member hearing panel shall hear and decide appeals from decisions of administrative officials and other enforcement orders relating to code regulations under Title 23. So we're under the same regulations. Now, the previous two that you've been sitting on had to do with the AG 38 policy, and that was, and yes, and this is only the 4th 3-member panel we've had, and panels and us are learning as we go. But the AG 38 partial height blocking policy was, that was kind of a different animal. It was appeal of a policy instead of an actual item, and we've been told since that we're supposed to accept appeals like that any longer. So, did you have that?
Just a correction, it was a policy RD.13.
I'm sorry, RD13, AD38 in the brain lately. Thank you, RD13. So, I think we do need to make the findings of facts, or you do need to make some, we do need to follow Part L.
So I have another question first. In this same area, you've built other homes, and that's actually been through the MOA submittal process versus the third-party review process that's being used on this. And have you gone through, even though they may have not had you fill out the actual alternate means and methods paperwork, have you had the geotechnical reports that have identified the 1.1 factor and the foundations have been designed to achieve that?
Yeah, what they recommend typically is the earthen pad, or they call it earthen mat foundation. It's geofabric, layer gravel, geofabric, layer gravel, geofabric.
So the alternate means and method isn't necessarily new to that area or to to that. It might be just the method that sometimes
It's
you
not-
fill out the alternate means and methods and sometimes. you
I
don't.
wouldn't call it alternate means and methods because the code specifically says, in these areas, you get a geotech report and you design per the geotech report. So we're really following code. I don't think it's an alternate means and methods.
One question. Do you take exception to the Muni looking at the geotech report and having it analyzed?
I feel like it's a waste of their resources, time and money.
I mean, you view it as a waste of time and resources, but do you, I guess the question is, what is your interpretation of the third-party review? That they have no rights to look at this and analyze this, or they do?
Well, I would say technically, if it's determined that an alternate means and methods needs to be filled out on every house that comes in that requires a geotech report, and the geotech report doesn't meet the slope stability analysis that's prescribed in IBC, which none of them do, is from what I've been told. And Ron, you look at me funny, but I had a conversation with Keith Mobley, and you say in this thing that he did a slope stability analysis per 1803 on a separate property, and he told me flat out that no, he did not. That was only on some fill, that was not on the area where the foundation sits. So I don't know, your impression of it might be...
Well, let's just answer the question.
I'm sorry, we're starting straight. What I'm trying to do is get these points so that I can start deliberating how I'm going to respond to this, because, again, it's based on the appeal.
I guess, so to answer your question quickly, if the municipality required alternate means and methods on every other house, then I would say they probably do have the right to look at this. But the problem is, they never required an alternate means and methods until a third-party plan review came through.
Okay, but you agree that geotech is required?
You're having the same communication problem I have with him. He means no. He just likes to give you the explanation beforehand that is to your side, the other side of the story when he's doing it. We don't believe that they have the right to even look at this thing. We think we turn it in, they're supposed to stamp it approved, and we're supposed to go on our way. That's what we think. And that's what Adam Tromley thinks. That's why there's a second ordinance, because, we brought this to them, to a bunch of assembly members and said, okay, you passed this ordinance, and here it is. Now look at how it's being administered. And so then they came up with something clear so that, that they would understand it. And so Andre is fair-minded and he's thorough, but, sometimes his answers, I think, lead you in the wrong direction.
Okay, so your position is, you feel the municipality doesn't have, through third-party right, the right to review and analyze the geotech report, that'd be one. And then, second, do you feel you have the responsibility to design to the recommendations of the geotech report and the code requirements relative to the factor 1.1?
Absolutely.
And do you feel that what you've submitted is compliant with all of that?
If I believe my engineer, absolutely. They don't let me decide this. It's taken out of our hands. We have to pay an engineer to do this. Two engineers, the geotech and the other guy. If you let me do it all, then I would take responsibility and build everything I can, the way I would like to do it. But, that's not the way I'm allowed to do it. I have to do it according to the engineers. And so that's what, that's where we're stuck with that. So we believe that we do it the way they've told us the engineers need to do it. We follow their direction 100%, and that's where we're at.
So then the last question, do you have a problem modifying your documents to represent the type of foundation that you're proposing based on the geotech report for the public record or for the record, whatever, your record?
Like he's saying, you put the box in and...
Well, however, it's clarifying that you have
Yes,
two solutions.
we have no problem doing that.
And the geotech report will address, or you'll have an amendment to that that addresses what is being
Yes.
proposed for the layers, et cetera?
Yeah. There's no problem with that.
Through the chair. The auditor said that it doesn't meet first of all, the geotechnical report's not adequate, and second of all, we didn't.
We understand that. Any more questions? Okay, if not, we'll enter the,
So I just got one more for Sharon. Sharon, you said something earlier that the municipality of Anchorage is, or the building official is the only, when you're in this third-party review, the alternate means and methods must be approved by the building official and cannot be approved by the third party. Is that, am I getting that right?
Correct. In Title 23, 2310, 103.3, which is powers and duties of the building official. Item 2310, 103, 311, alternative materials, design, and methods of construction equipment. The provisions of this code are not intended to prevent the installation of any material or to prohibit any design or method of construction not specifically prescribed by this code, provided such an alternative has been approved. The alternative material, design, or method of construction shall be approved where the building official finds the proposed design is satisfactory and complies with the intent of the provisions of this code, and the material, method, or work offered is, for the purpose intended, at least the equivalent prescribed in this code in quality, strength, effectiveness, fire resistance, durability, and safety. The option for exempt plan review does not grant those powers to the independent reviewing professional, and that has been corroborated by municipal attorney Dennis Wheeler.
We have copies of that if you're interested.
I've got a copy of it right here.
Of the alternates of the municipal attorney.
But you want to mark that? This is the law, or this is the code.
What I just read.
What
What you just read is, yeah, chapter 22.
any other questions? Okay, so the questions phase is now closed, and we'll enter the deliberations phase.
I'll make a motion to approve the amendment, or excuse me, the appeal.
We haven't been conducting these two panels in terms of that strict of parliamentary procedures, and I think with only 3 people, I mean, the chairman can't make a motion. Another panel member has to make the motion, and it would have to be seconded by the other panel member, right? So that would be all 3 of us.
Well, so then how do you want to go about it, Mr. Chair? You want to move forward that we're going to vote on approval of the appeal, or are you going to vote on disapproval of the appeal?
What I would suggest is that after we deliberate, we have a vote, and the vote of yes would be in the appellant's favor, and a vote of no would be not in the appellant's favor.
And the nature of the deliberations amongst ourselves.
What would they be?
Yeah, I mean,
We would each just give our opinion on how we're evaluating it.
okay, thank you.
So I guess I'll start. What I see is a permit that was submitted under the third-party review that has met all the requirements of the ordinance for the third-party review. And what that ordinance says, if all the requirements have been met, then the building department shall issue a building permit. And what's happening here is now that the building department has said, well, there's an alternate means and methods, and is kind of use that as a way to stop issuing of the permit. And for it to be an alternate means and methods, there has to be some issue with it where the code has not been met, and from what I can tell, the code requirements, including the local amendments for the requirements for seismic hazard zones has been met.
Okay. Guess I'd first like to just address some findings. The property is a single-family, is that correct? Residential. Geotech investigation was performed by Northern Geotech Engineering, Inc. The project was engineered by Schneider Structural Engineer. The appellant undertook a third-party review, and the structural design, as code compliant, was conducted by LDR Engineering Services. And the final is the property is located in Northwest Turnagain Seismic Hazard Zone 5 and requires geotechnical engineering report and responsive design. So, in looking at the appeal, and I hate to go so narrow, in looking at the appeal, I can't help but, we've had a lot of conversations, we've got a lot of information, but the appeal is solely based on this policy. And as far as I'm concerned, everything in terms of the engineering is not part of the appeal. It's good background, it's good experience, but I have to say that you put this forward in good faith, and it was to say, does it deviate from the policy? So my specifics are going to be speaking to this policy. And with all appeals, my understanding is the burden or the evidence lies with the appellant. And I'm hearing history and information both from both sides, but I don't have enough in front of me or enough specifics to conclude that one outweighs the other in terms of fact and the like. In my mind, if someone were to act in the same way in terms of a result, either by doing this or this, but it gets it to the same point, I would give the benefit that is creating a policy of getting to the same result, which is that you go through this process, you're going to be looking at a alternate engineering or design, and these based on the geotech report, and your engineers coming up with a solution that meets the code. So I don't know that I'm seeing a policy change. Now, I recognize frustration with this in terms of maybe the form and the like. So I don't, but I'm, again, not getting enough specifics tonight presented that's telling me that there's deviation from this policy. So again, going to the narrowness of this, the appeal is based on this policy, I can't support the appeal.
This is really tough. There's a lot of information that was provided to us tonight for us to make a decision right here and now, I think, or either in support of or not support of. It does appear that I kind of have to agree with John here on when we got this information, in reading this, it is what your appeal is based on, is whether they've changed their means, whether they've changed their process or procedures with this appeal is even attached, as John was pointing out, the municipality of Anchorage operating policy procedure. Again, some conflicting information about, has this been provided before? Is it consistently required in that area? I think that it's been indicated that, maybe not as consistent as they should require the actual paperwork, that there's a form that fortunately a lot of us don't see that much of, the alternate means and methods, that through everybody's careers, I'm sure we have. We know we have, but it's been indicated that whether the form's been required or not, the homes in this area have had designs and have had reports, the geotechnical reports and foundation designs that have conformed to the geotechnical report that meets code, and specifically the 1.1 safety factor, or factor of safety. So I guess based on the fact that the appeal is based on the policies and procedures, I have to agree that it's difficult to support the appeal, and based on the appeal facts, or on the appeal that's based on the policy and procedures, a change of operating policy or procedure. All I have to say.
So I understand what has been said here, but when I read the appeal, although it may not state it explicitly, it seems to me the intent is that, in the past, alternate means and methods has not been required for these high seismic zones or hazard zones foundations. And now it is being required, and that's the change. I think that's the intent of the appeal, and so we can take it as it's written, and maybe understanding what's intended, but ignoring what's intended and take it as it's written, and not find in favor of the appeal. And then that puts the appellant in a position where they need to probably rewrite it and go through the whole process again, which puts.
Can we ask more questions? We've been here for an hour and 25 minutes, and lots of engineering reports and everything, and it's hard to digest a lot of this information, particularly if you're not actually a structural engineer. There may be some advantages to that. What I can understand is how this is written, and with the attachments that was attached to it, which is the Municipality of Anchorage Operating Policy and Procedure, and certainly don't wish anyone to be going through this or having to go through it. And
I don't know that we need to get bogged down into all the engineering, and I don't know that would really be productive, because I think the comment that was made earlier, you put 10 engineers in the room and you're going to get 10 different answers. There's some truth to that. So I don't know that we really need to get bogged down into that. I think the issue is that an alternate foundation design was conducted by both the structural engineer and the geotechnical engineer, but it wasn't submitted as an alternate means and methods. And building safety has has chosen not to accept the application based on that.
They did
I think
turn
that's
in-
the issue.
They did turn in an alternate means and method.
Only
And they-
only after the municipality asked them to, once they turned in all the information that was required.
At the time, it was required. So they've done the report, now they're asking for an appeal based on past history, and I guess in my mind, it's again, assuming, I'm sorry, I interrupted you.
No, go ahead.
So I'm getting a sense of possibly you're supporting the appeal. I'm getting very narrow in how I'm looking at it, that it's an appeal, and I think you're spot on, that if this is important enough, we'll probably see it coming back as an appeal. But, and we wasted an hour and 20 minutes if, or I'll soften that word, we haven't wasted, we've been involved in this, but I'm not hearing and I'm not receiving enough information, one side or the other, that's convincing me to go one way or the other in terms of conclusion of law. I mean, I'm sorry, we're past questions here, but we're deliberating this. So I guess my point is to just say, okay, we accept the appeal. I'm not seeing anything or any discussion on your part that says, okay, what do we think about these issues that have been brought up about the review by Golder? The fact the drawings that we have no right to be reviewing aren't indicating how that sublayer is being built up. So how would you say municipality or we have a responsibility to bring this on track to make it right if we just say, okay, we'll grant the appeal? What does that do? What does that trigger? My sense is it doesn't trigger them to do anything more.
No, and that's why I asked the question if they intended to build the foundation according to the geotechnical report, which would mean that, yeah, it's not on the drawings because the structural engineer said, no, we don't put that on our drawings. But they would get built that way because it's required by the geotechnical report, which is part of the permit application.
So right now, it could be built one of two ways. Or I guess the foundation would indicate that it's being built up sublayers, because it wasn't a mat foundation.
Well, I believe it was stated that they gave two different alternatives for how the foundation's built in the geotechnical report, and they would build the foundation according to one or the other of those.
But would it still go through the municipal review process? They would then submit it, and it would be reviewed, or it's just this ends it, and the house gets built on one of those two methods that was suggested?
If we find in favor of the appellant, I think there's two possible ways forward. The building department would grant the building permit, and it would be constructed, or both parties have the opportunity to appeal the three-member panel decision, in which case it would be taken to the full building board. And so the municipality would either have to issue a permit or appeal this panel's decision and take it to the full building board. Those would be the two ways forward.
Or the appellant reappeals on another basis.
Yeah, if we did not find in favor of the appellant, then he could reapply with a different appeal. That would be time consuming because you have to do the public notifications and get the panel, and
So I guess I would ask for part of the discussions, how would the closure be made on the deficiencies of the documents that aren't addressing, again, another geotech's perspective, or how things are going to be built? Or am I not being savvy enough and you're saying that the documents are showing that path?
well, I mean, what I heard is that the foundation would be built in accordance with the foundation requirements of the geotechnical report and the structural engineer's design. That's what I heard when we were asking questions. The fact that Golder has identified that there's some issues they have with the geotechnical report, I think that's kind of getting a little bit tertiary to what we should be considering. Anytime you have one geotechnical firm review another's work, they're going to find issues. With a technical topic like this, they're going to find issues. Just like any time a structural engineer, I review another structural engineers that are drawings, I'm going to find problems, or what I perceive to be problems.
Well, it's like, maybe I'm just road weary of these processes, but I get tired of coming to these appeals, and we don't have the detail prepared, and it's not presented, and yet we're being asked to render decisions on detailed information. I don't have enough here that tells me one way or the other. I do have a sense that the politics of this town, through recent action, has said that the building department and the home builders can't get along. And they've passed ordinance to the effect to where they don't have to get along, they can go another avenue and third-party review. And I guess the part that gets me is you've gotten all of this correspondence, and I'm not hearing anything in rebuttal other than specific questions that are brought up. So I view that as not really being prepared to deal with the issue. And it's again boiling down to just taking the fact that we don't want to deal with you. And it's a sad state. I'm not saying this to be punitive or bark at anyone. I'm just saying it's a sad state that we can't get along. I mean, as a designer, I can come in and recognize that things have to be worked out. And I guess I don't have the same level of monetary investments as a developer and a builder that you may have, and the frustrations. But I can tell you this, that I see you guys get permits in probably a tenth of the time that it takes me to get a permit, mainly because it's commercial versus residential. So, I'm still in this dilemma of comfort level of if we act on the appeal on the basis that the mat's going to be provided, that's going to be per the report, engineers are not going to get along, and so you basically are going with your engineer's recommendations. And I'm assuming that Snyder has based their design on this layered system, but I don't know. I mean, it's just...
No, we're just deliberating, sorry. I know it's frustrating.
I'm sorry, I'm throwing out things that make you want to respond, but I'm just trying to, trying to come to a decision on this that is positive in the reality of where things are going to go, and not waste a lot of time and effort again.
I mean, you've made all valid points, and I
think we have an ordinance in place that hasn't been road tested. And I think we're getting a few of these bumps in the road. And I think they're real things that need to be addressed, and I wish Mr. Trombley was here to witness this.
Yeah, there are gray areas within the ordinance or situations like this which are kind of undefined when, what is acceptable to require alternate means and methods? Because once the building department requires alternate means and methods, and they're kind of involved in the process.
And it's when you don't have a design you can show. It's for, I imagine, engineering, it's you laying out calculations that get you to that. For like an architectural and exiting solution, it's pointed out that we don't comply with this. So we say, okay, we don't comply with this and this and this, but we, in the design, are offering this, this, and this. So as an alternate, we're letting the department, the interpretation, the building official, reach a point where they say this is an equivalent to what the code is trying to get at. And that's what the alternate is about. And so if you don't have it solved by the exact language of the code, then you have to come up with another way of convincing everyone that it's in the benefit and in line with the intent of the code. So, I don't know about that, I'm sorry.
Yeah, and when I'm looking at this and what's presented today, what I'm seeing is that all the code requirements have been met with the site-specific geotechnical report and a design that meets the requirements of the geotechnical report. That's my interpretation.
And it's been evidenced in your mind that it's in place.
No, I haven't seen the documents. I'm basing on that and what I've heard today.
And that's the point I'm making. I'm hearing this side, I'm hearing this side, I'm not seeing conclusive.
Yeah.
So this side is supposed to conclusively show me that I should be saying yes, and I'm not seeing that. That's the basis of the appeal. It's kind of, I view it as the burden of proof with them, and I don't know, maybe it'd be fair to ask staff if that's in fact what the building board is to be basing this on, some kind of evidence, or has it become, just more of the feeling of, and I'm not saying it's a bad feeling you're having, my stomach's all eaten up as to which way to go, but I'm not seeing conclusive one way or the other.
All right, any further deliberations? All right, well, let's vote. I don't have a, do you have that? Okay. So, I'm kind of doing this because I said I was going to do it in the beginning, and I'm trying to follow.
So can I have one without, has the same markings as yours?
These, Hannah gave me these, so we'll just take what we're given. Okay, so again, a yes vote would be finding in favor with the appellant, and a no vote would be the opposite. So the findings are against the appellant. So the appeal is not granted.
So in form of, if I might, I guess, some more conclusion of the findings, I think I stated relative that should be able to be extracted pretty much from the outline of the case history. But maybe his conclusion of law is that at the time of the submittal, which we're hearing the appeal for, the requirement was for the submittal of the geotech report. The report was reviewed and raised questions in terms of engineering evaluation, and that there hasn't been evidence speaking to the issue of the foundation design resolved, and the fact that the appeal was made on the procedural process. The end result is the conclusion of law, that it gets to the same point, in my mind. And I guess adding that the building official does have the right to seek alternate, a request for alternate methods, alternate means and methods.
So can I ask the building official a question then?
Well, I guess we can go to the next phase, which would be like closing comments and kind of maybe open it up for discussion about how we move forward from here. So yeah, go ahead.
So, from what I understand, there is no third-party review in seismic zone 4 and 5 any longer in the city of Anchorage. Is that what you found? Because that it would all require alternate means and methods, and it would all have to go through the building department.
No, I think what we found is that the appeal, the way it was written, was denied, is what we found. I think that I think the appeal needs to be written more to what you're getting at with the comment that you just made, is that, this, is it an alternate means and method when you've met all the code requirements, and the appeal needs to be written and...
We can talk about this when we get finished, but this is a quasi-judicial hearing that you really do need to finish it up. We need to talk about appellate rights, and we need to give the whole board, some training and handouts with respect to the proceedings. So
Okay.
you've made your vote. You need to conclude. If you have any more findings are very important in all these cases. And the appeal rights basically are full board within, did they change the appeal time?
I don't think that's changed in a second.
So is it 30 days? 30 days.
Let me verify those.
So we need to advise the appellant his rights of appeal is one of the things we need to do. And so you have the right to appeal this to the full building board. And I'm not sure exactly what the timelines are, but it's, if you're going to do it immediately. Get the process moving.
The person with the right to appeal has 30, that's the date of action. Okay, after the voting, discretionary de novo rehearing in its sole discretion is determined by majority vote, 50% plus one members, let's back up, not disqualified from voting under the subsection provided below. The building board may accept an appeal decided by a 3-member hearing panel in whole or in part for de novo rehearing by the full building board. Application for de novo rehearing, de novo means new, starting from over and rehearing, by the full board may be made by any party or by any member of the building board. Application for de novo rehearing by the full building board must be filed with the secretary to the board within 5 business days from publication of the hearing panel's written decision. So customarily, we've had a memo out the next day publicizing, publication of your decision. Within 5 days of that publication, any party can request a de novo rehearing of the full board. Then the full board, minus the 3 people who are on the panel, determines whether or not it wants to accept the appeal for rehearing. If the de novo rehearing is accepted by the building board, members of the hearing panel first appearing the appeal may participate in the rehearing as members of the full board. So, according to the ordinance, if a person wants to appeal the decision made tonight, they submit that request within 5 days of the publication, which we'll have out tomorrow, and we'll send the appellant. And then the request for full hearing goes to the remaining sitting members of the board.
But they also can request to be heard by the full board.
It says any application may be made by any party or by any member of the building board.
So the stuff going out, the summary, will go to all the board members.
And so, so if they determine, if they do accept to have a rehearing, we start completely over on this appeal with the full board.
Would the appellant have the opportunity to change the appeal, or would it be exactly
No,
just
that
what
would
we
be
have to hear?
a new action.
Right, so,
That would be a new action.
You need to consider that.
And that's another, like you said before, that could be another option. They could come with a brand-new appeal tomorrow to 3-member panel. Could be, accept this decision and come in with a different appeal.
So even though they passed the deadline to appeal, that's a question. So if they come into a new appeal,
It's brand new. Everything starts over.
and as a result of this, is what you're saying, they can come back in and pass the deadline?
What happens tonight has happened. So their options are appeal this decision of this appeal, or accept this decision, set it aside, come in, if they have a different appeal on the case, or a different type of appeal, that's a whole new case. Starts all
So
over.
appeal the decision to the full board,
No.
or
Or appeal this
Or-
decision to the full board, or come in with entirely new and different appeal to the 3-member panel.
And there's still the avenue of the courts, correct?
Yeah, it's 30 days to Superior Court.
Yeah. Well, I'm just making sure all this.
Well, I will address that. In order, and of course you can consult your own attorney, but generally when you have administrative appeals like this, to get to Superior Court, there's a doctrine that says you have to exhaust your administrative remedies, meaning they would first need to appeal to the full board.
Okay.
And the board would either take it or they'd say, no, we're not going to hear it. At that point, then you've exhausted your administrative remedies, and you can, this is a little unusual because you've got this two-step process. Usually with administrative type things, it's just one hearing and then you go to Superior Court.
so do you understand your options?
Yes.
Okay, we're adjourned.
Chuck, maybe we could talk about, exactly what it does mean.
What does it mean?
Honestly, there wasn't any, copy of this?
We don't need any copies. You need copies of every alternate means and methods form that we had filled out in the last year, and every house you permitted in seismic zone 4 and 5. That would be something we would need.
Under any good discussion, since we're all
The
here.
difference between alternate means and methods and then reading the code through alternate design.
We need that discussion.
It's October 10th. We don't have time to go through the courts or do anything else. We just want to get the building permit.